case number 90198, State of Kansas v. Jonathan D. Carr.
May it please the Court, Sarah Ellen Johnson of the Capital Appellate Office on behalf of Jonathan Carr. Merrill Carver-Allman did the same office with her at table, and we are ready for argument.
May it please the Court, Assistant District Attorney David Loudon on behalf of the state.
Kim Parker, Chief Deputy District Attorney on behalf of the state.
May it please the Court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state.
Very well. Counsel, you may proceed.
Good afternoon, Your Honors. May it please the Court. Your Honor, I would like to reserve 15 minutes for rebuttal, if I may.
15 minutes is granted.
Thank you. I would like to begin our presentation today by returning to the Batson issue that I heard being discussed this morning. I have some thoughts that I would like to contribute to that discussion. First, I would like to note that the District Court's decision on the refusal to allow the strike of Juror WB is not entitled to tremendous deference by this Court simply because of how flawed that ruling was, how lacking in following the Batson steps that it was. As Justice Johnson pointed out earlier, it's an abuse of discretion to violate the law or to not to follow the proper legal steps, and that is where we are right here. As it relates to Jonathan Carr's attempted use of a peremptory strike on Juror WB, who I'd like to point out we also challenged for cause earlier, the District Court didn't even wait for the state to make an official challenge to our attempted use of the strike. In fact, the District Court invited the challenge from the state, turned to the state and said, is there a challenge? As if to say, I've already made up my mind, state, tell me you're challenging, and I will refuse to allow this peremptory strike.
So what is the prejudice that's suffered by the court incorrectly not allowing a peremptory challenge? We have a jury that's fair and impartial by using the strikes for cause standard or the showing for cause. What is the remedy here? I guess I asked that this morning, and I still haven't heard an answer that is satisfactory, at least in my mind.
Well, first, Your Honor, I would like to point out that we have raised an issue challenging 3 of the jurors who ultimately sat on the jury as having been improperly not excused for cause. That's in issue number 37 in a supplemental brief that we filed about a month or 2 after filing the initial brief. So we do dispute that these cause challenges were appropriately handled. So we would dispute from the outset that we have an unbiased juror. And this particular juror is one of those 3 jurors that we challenged for cause and that we maintain on direct appeal was an improper cause decision by the District Court. So we have that prejudice. Further, the prejudice is having this juror that should have been allowed to strike, that we properly provided a basis for striking, that we attempted to strike, that the state didn't dispute any of our statements about what this juror's attitude in the court was. So we have an unchallenged assertion that this juror was sarcastic, was contemptuous, was dismissive of mitigation, was very pro-death penalty, and then this juror proceeded to hear the case, proceeded to, in fact, be the foreperson of the case who first found my client guilty.
Does it matter what the basis is for the challenge to excuse the juror on a peremptory? I mean, here you've articulated some reasons that you believe are race neutral, but does it matter? Let's say you just didn't like the way the juror appeared, which you have the right to do, and other than making it a race-based kind of appearance,
correct,
you can just say, I want to strike. Would you be making the same argument that you had the right to strike that juror?
Absolutely. We're entitled to 12 peremptory strikes as long as we're not engaging in racial discrimination against a particular juror, which I think is, from my understanding of Batson, that's the core of the Batson concern, is protecting individual jurors from being racially discriminated against. So in this case, where we've offered multiple reasons that have nothing to do with the race of the juror, we were entitled to use that strike. I would be making that same argument no matter what our explanation was. And I would urge this court to look to the 609 letter that we filed a couple of weeks ago, wherein we cited an Iowa Supreme Court case that came down in 2012, post-Rivera, considering what is the remedy for a reverse Batson issue like this. And that court said reversal is the remedy, because there is no other way to correct this. The problem is that that juror went into the jury room. The problem is that the district court erred in allowing that juror to be on the jury room, despite
I'm still having trouble filling in the blank. Justice Rosen's question is, the prejudice is blank. And so is the prejudice that you wanted to use your challenge and you didn't get to?
That is part of the prejudice, yes.
What else?
That juror that we did not want on the jury and we were entitled to strike participated in deliberations.
And that's what I don't understand, because if we were to disregard your striking for cause argument, then you're back to Justice Rosen's question, which is you've got your pool and they're fair and impartial. So now you've lost one. What's the prejudice from that? I can understand you had to use a peremptory, that you had to use your peremptory challenge somewhere else. But okay, and they got in the room. So a fair and impartial juror got into the room. So what?
That's the prejudice. That juror that we were entitled to strike, that we didn't want on the jury, and we struck and were entitled to strike, served on the jury. And that's what the Iowa Supreme Court found in the Moots case that I recently 609, is that the prejudice is almost unnoticeable. We can't know what exactly the prejudice is. We don't know what happened in the jury deliberations.
Let's go at it a little different way. What is the underlying purpose of a peremptory challenge? Is there a constitutional due process basis, or what is being accomplished by allowing peremptory challenges?
There's not necessarily a constitutional basis to the peremptory strikes. There is, I would argue, a due process challenge, because we have a statute that says we're entitled to these strikes, and so you do have a due process problem if they're arbitrarily denied.
In the respect that essentially it's allowed the state to pick your jurors for you, because the state can challenge your challenges?
Absolutely. The point is to allow the defendant to be a participant in jury selection and to not just be stuck with necessarily the first 12 people who walk in, but to have some say and to say, this juror seems off to me, or this juror isn't somebody that I want judging my case. I don't trust this juror. We've set up this system for who knows how many decades, allowing defendants to participate by the peremptory strike. And when one is arbitrarily denied, and that juror is made to then sit in on the deliberations, be part of the decision-making process, and in fact, not just vote for guilt, but then also vote to send my client to death row, that's the prejudice.
Ms. Johnson, you mentioned the Iowa case.
Yes.
If memory serves, since Rivera said that states could decide whether they were going to apply a harmless error kind of analysis or not to this kind of error, it's 5 and 5. 5 who say that we will apply harmlessness and 5 that say we will not. What makes the cases from jurisdictions that say we will not apply harmless error more persuasive than the others?
Whenever we're talking about what goes on in the jury room, the defendant is automatically at a disadvantage in terms of trying to establish what that prejudice is. There's no way to know how that one juror being on the jury affected the entire course of deliberations, from demeanor, from maybe that juror directed some questions, or maybe a different juror would have had entirely different questions. We can't know. We're talking about putting together 12 people, and when you take one out and put a different one in, you're going to have an entirely different dynamic. Certainly as to the penalty phase, clearly one person could have made the difference between a life verdict versus a death sentence in this case. So obviously one juror makes a tremendous difference at that stage. I would argue it makes the same difference at guilt phase. And I would also submit that there is no sound reason for applying a remedy to this issue only to penalty phase as opposed to the trial. What we stated as our reasons for wanting to dismiss this juror should not determine what the remedy is. The problem is that this juror served on the jury. What we stated in court may seem only to apply to the penalty phase, but the juror sat on the entire trial, and I'm troubled by the idea that what the defense attorney says, articulates in the heat of the Batson moment could dictate what the remedy is for this issue. I think the cleanest thing to do is to say the remedy is reversal of the trial in its totality. I would also point to the fact that a lot of social science research has suggested that death-qualified juries are more likely to err on the side of convicting. And so, yes, the death qualification process has been shown to lead to more conviction-prone juries. So in that respect, I would submit that it does make a difference at guilt phase and not just at penalty phase. If there are no further questions there, I would move on to the severance issue. I think this morning's hearing makes it somewhat clear that Jonathan Carr was in fact facing 2 prosecutors in that courtroom and not just one. The trouble is that the second prosecutor was his brother, and that's a pretty powerful indicator of guilt, to have your brother sitting right next to you and saying, it was all him, he did it, he did it, he did it. That's a level of it's not proof, it's not evidence, but it's a very powerful factor in a courtroom to have the defendant's brother saying, it was all him. There's no way that that couldn't have affected how the jury ruled on this case, how the jury saw the evidence, the lens through which the jury considered everything. I would also point out that Reginald, throughout this trial, engaged in what I might call some antics that, again, because he's sitting right next to my client, Jonathan, sucks Jonathan in. There's the day that Reginald just decided, I'm not going to come to court. That has a negative impact on how the jury sees Jonathan, too, especially given the way that these two were treated as sort of one entity. We have Reginald being required to be in court with handcuffs on. Now, we don't know for sure that the jury saw that or didn't see that. We do know that the district court provided Reginald with something to cover the handcuffs, and Reginald declined to use that. And the district court said, well, Reginald, you're bringing any prejudice on yourself on that.
That was during the penalty phase.
That was, yes. But I would point out that the handcuffs were on during the guilt phase, and the record's simply silent as to what efforts were made to cover the handcuffs during the guilt phase. But certainly we have, during the penalty phase, the district court saying, Reginald, you brought this prejudice on yourself, and paying no mind to the fact that Jonathan had done absolutely nothing at this point. In fact, the district court said Jonathan's behavior in court has been perfectly appropriate. We also have another incident where that was put on the record where apparently Reginald scooted his chair right up to the district attorney, maybe touched her in some way, all very certainly inappropriate behavior that then Jonathan Carr's defense is prejudiced by because he's being viewed through the same lens. He's sitting right next to Reginald Carr. These things wouldn't have happened.
The behavior toward the prosecutor wasn't necessarily visible to the jury, right? We don't know that on the record.
We don't know that.
Okay.
We don't have a clear record if there were other incidents. We don't know if the jury saw that. The jury was never asked, unfortunately. But those are the incidents that we know about that were put on the record. And all of this happened because Jonathan and Reginald were tried together, and because we simply didn't give them each the separate trial, certainly the separate trial that Jonathan was entitled to, so that he would not be tainted by both the behavior of Reginald in the courtroom and the finger-pointing by Reginald's attorneys that would never have happened.
What finger-pointing did they do towards in the guilt phase?
There was
The defense was he wasn't there. How's that pointing fingers at? I mean, Reginald, your defense was Reginald did it. How is that? How does Reginald's defense that he wasn't there?
There was,
Yeah, I understand what we're arguing this morning is has potential difficulties, but what about for your client?
there was a comment, an opening statement that we objected to, moved for mistrial over, that was Reginald's defense attorneys bringing up this, it was Jonathan and some other guy. There was also the testimony through Stephanie Donnelly saying that Reginald was very angry with Jonathan that morning. And in fact, even after our objection was sustained to that, defense counsel for Reginald went and had her say it again, or asked her again, so Reginald was angry at Jonathan. Those are the best examples from the record that I'm familiar with. The behavior of Reginald is a much bigger component in our severance issue
Okay.
than.
But it's not so much the antagonistic defense, it's more just the whole environment of having two co-defendants there and their siblings, and the behavior of one can be applied to the other. That's
Yes.
more of it.
There were certainly antagonistic defenses. We're certainly maintaining that. And, we were denied putting on a statement that Tronda Adams heard Jonathan say that morning about what did smoke Reginald get me into. We weren't allowed to put that on. And could that have come in, at least at penalty phase, at a trial that didn't involve Reginald? And I would submit yes. So we were denied that. And we were also simply...
Let me refresh my memory on the facts on that. She overheard Jonathan say that in a telephone conversation he was having with his sister?
Correct.
And that was excluded on motion and limine by the state?
That is correct. So again, our argument is that there were antagonistic defenses and that we were prejudiced by the actual behavior of Reginald in the courtroom. And throughout all of this, I would urge the court to remember the final issue in our guilt phase brief, which is cumulative error. I don't think that's something that any of us can overlook in terms of how did all of these individual little things pile on and create a fundamentally unfair trial for Jonathan Carr. We've talked about the denial of this one juror. We've talked about the failure to sever. I've talked briefly about challenges for cause. We also have an issue where we've argued that the district court was biased in the way that the court addressed challenges for cause, granting almost every challenge for cause made by the state and denying almost every challenge for cause made by the defense, and in fact often rehabilitating the state's or the defense cause challenges and the opposite of rehabilitating the state's cause for challenges. All of these things sort of start to pile on, and we have to ask the question of, fundamentally, at the end of the day, was this a fair trial? All of these errors combine with each other, and I would urge the court not to overlook that portion of our argument. I would like to move on. I know Justice Beyer had expressed an interest in the aiding and abetting instructional issues, and we've
Counsel,
raised...
before you do that, can you address the related issue of the amount of evidence against your client if you're raising this cumulative error?
I think actually the aiding and abetting instructional problems go to the level of evidence, actually. As certainly as far as the capital murder counts go, the evidence is really, there's no fair inference from this evidence that there was anything other than one shooter. If you look at all the shots came from one gun. And if you look at the trajectory of the bullets, they all originated from the same spot. It went 1, 2, 3, 4, 5. The idea that the gun was being passed back and forth simply doesn't match up to the physical evidence, the fact that there wasn't much gap between the gunshots. There was one shooter. And the evidence is clear that
But that's an argument from the evidence, what you just said. That's not the evidence. The person who talked about the trajectory didn't say firmly only could be one shooter. We don't have that positive statement from a witness, do we?
I don't know that we need that, though. We have,
I understand you can argue inferences, but we don't have an expert on the stand saying this is a one-shooter deal.
no, but no expert would be able to say that. But it would involve, in this case, I take a shot, okay, now I step back and let you take the gun, and you take the next shot, and then you step back and I step back into that place. The trajectory does show the likelihood is that they all came from the same position.
Okay.
So no, from my view of the evidence, there really isn't a reasonable inference that there was anything other than one shooter. We know that it was all the same gun. We know it was not the gun that the eyewitness saw Jonathan with. Jonathan had the silver gun. The murder weapon was the black gun. So we have a situation where one person is the shooter and one person is not. This gets us into the aiding and abetting, and as far as the great weight of evidence towards capital murder, my position would be that we don't have clear finding by the jury that my client, Jonathan Carr, separately premeditated and intended these killings. And that's a necessary component. We don't have certainty that the jury made that finding. They were certainly instructed that they could find him guilty of crimes that were reasonably foreseeable, not even as a probable consequence of the crimes that were agreed to, just reasonably foreseeable. And that, as we know from Overstreet, Englehart, that instruction is incorrect as relates to premeditated murder. It's certainly, if that's true for first-degree murder, it has to be true for capital murder. And that gets us to the position where we don't know. We don't have overwhelming evidence to declare any of these errors harmless based on the idea that it's clear that a jury would have found Jonathan Carr guilty of premeditated intentional murder had they been correctly instructed that that was the finding they had to make.
Well, the evidence of premeditation goes further than just the actual shooting itself. The evidence of premeditation starts way back when they're putting them into the vehicles, they're separating them, they have a very calculated plan, the evidence is that they're both involved. There's all kinds of evidence that points towards premeditation beginning at the house and going all the way there, and you're just focusing on the shooting itself.
Well,
And speaking of the shooting itself, address the fact that there is at least was time for whoever wasn't the shooter to object between shots and to try to stop it, as opposed to assisting by standing back and being silent.
well, of course, standing back and remaining silent isn't the same as specific premeditation. Mere presence is not sufficient. As far as all of the activities before, I would point out the Schreiber incident where the person was taken out into a field to be left there, and tires shot out so that he couldn't get back to call for help in time to catch these people. This is consistent with that, potentially.
But the eyewitness here testified that when she was first taken out in the vehicle, they hid themselves, the driver hid himself, didn't want her to look at him, but she noticed specifically that when they were driving to the field, they didn't seem to care if their identity was known, or he didn't seem to care. And that was the difference between that and the Schreiber incident, where he was not allowed to see his attacker.
Except, of course, Schreiber was able to see Reginald Carr. I don't recall any claim that Reginald was truly concealing his face when he walked up to the car initially. But I would also suggest that perhaps having...
What about the fact that there seems to be a plan between the two of them to separate these individuals and put the men in the trunk, put the women in the back of the car, drive out there, have them kneel on the ground, shoot them execution style? Isn't that all evidence of premeditation and aiding and abetting, even though it's not the actual shooting?
I would argue that that is also, at least putting them in the car, separating them, driving them out to a field, is also consistent with what was done with Andrew Schreiber in leaving them out there. so that they couldn't call for help immediately.
Well, to clarify, counsel, you're not arguing that insufficiency of the evidence, are you?
No,
You're arguing that the evidence was not so overwhelming that it negates the instruction error on aiding and abetting. Is that what you're arguing?
absolutely correct. Arguing that the jury was not told that they needed to make the finding that they needed to make, and that there is at least credible evidence from which they could find reasonable doubt, at least as to premeditated intent by my client, and that, you know, they're tried with the Andrew Schreiber incident, so we know that there's a history of leaving a person in a field and trusting, you know, this is 7 days earlier and nobody's been caught for that, so perhaps they're a little more comfortable with that idea that that really will work out. But again, as Justice Johnson said, the critical problem is that the jury didn't make this fact finding. And we do have a pretty solid basis of evidence to suggest that there really was only one shooting and that the jury really did need to make this premeditated intentional finding as it relates to both the shooter and the non-shooter. And they were not told that. They were told that they could find either defendant, Jonathan Carr, guilty based on this crime being reasonably foreseeable. And I think clearly many of us would say it could be reasonably foreseeable that you have guns and you know, engage in some of these behaviors, that a shooting is a reasonably foreseeable consequence at the end of the day. But that's separate from the jury having to find that Jonathan Carr himself formed the premeditated intent.
This argument isn't specific to your client, is it?
I think it's
You may
better
be the
for my
only one-
client.
You may be the only one who made it, but it's not specific.
I would always argue that the reasonably foreseeable instruction is incorrect
As
as
to both
relates to
defendants.
any premeditated intentional killing. The facts of this specific case show that the gun that was the murder weapon was not in Jonathan Carr's hands. So on a factual level, I think it's much stronger for Jonathan in this case.
Just because of the gun, who had possession of which gun?
Correct.
Well, is there also a factor in here of who was driving which vehicle?
Yes, that also plays into it, that
Jonathan, go ahead and give me the facts of that.
Jonathan was in the truck and Reginald was in the other car.
The truck went first, didn't it, to the field?
Yes, but it was the individual in the car who got the men out of the trunk and had them kneel down. That's always been my interpretation of that testimony anyway. If there are no other questions on that issue, I would like to briefly discuss the venue issue. You know, obviously those issues don't have a great track record at this court, but I would submit if this is not the case where a change of venue should have been granted, where a district court abused its discretion in failing to grant it, then there never will.
What in your mind does it take pre-voir dire, pre-jury selection to meet the presumed prejudice? Is there some kind of magic number that we should be looking at when we get these? We had a same kind of scenario last week in a case involving a rural area. This is an urban area, but the same questions came up regarding the same kind of scientific evidence.
I don't know that there can ever be a magic formula to decide this is the case, you know, these numbers are the right numbers. We have, you know, from the survey that Lisa Dahl did, we have 96% media saturation in Wichita versus a significantly lower number in the comparative study done in Wyandotte County. We have 75% fixed opinion of guilt in that survey versus I think it's 20% in Wyandotte County in that study. And I think the jury questionnaires that came through bear that out, that media saturation in Wichita was extreme, that Sedgwick County, you know, had a hard time walking down the street and finding people who didn't know about this case. Maybe that was a little easier than walking down the street and finding somebody who didn't have a fixed opinion of guilt, but those opinions were pretty well established through this study that Lisa Dahl did, and it was corroborated by the jury questionnaires and the jury selection process.
How do you get around nearly every jurisdiction in terms of determining actual prejudice based on pretrial publicity, bases that on voir dire and bases that on questioning jurors? And in this case, there was no finding of actual prejudice based on seating a fair and impartial jury. How do you get around it? That is the test, and that is the way that to validate the scientific evidence.
Well, again, this is where I would point the court back to some of the other issues that we've raised about jury selection. That it's easy for a district court at the end of the day to say we have a fair and impartial jury when that district court is the one making all the decisions, and that district court is denying almost every single cause challenge that the defense makes and granting almost every single cause challenge that the state makes.
It's a little different question, but go ahead.
It folds into the same point. We have multiple cause challenges that we've raised on direct appeal that we feel the district court was incorrect on. And so if we already are at a point where the district court is not properly seeing biased jurors and not striking them from the jury panel, for that district court to then go on and say, well, clearly we have a fair and impartial jury, it's a self-fulfilling prophecy. The district courts...
Are you saying that it's when the court says we didn't have any problems picking a jury, that's influenced by whether the judge grants challenges for cause?
Well, I'm saying if the district court doesn't see any problems and denies every problem that the defense raises.
What about looking at it from a different standpoint? And I see your point. If you're looking at the number that were challenged for cause, we have one person that's in charge of that. But what about the number of challenges made by the defense? What are we looking at here as to how many of the jurors were challenged for cause by the defense counsel?
I don't have a percentage breakdown in my head of how many jurors were voir dired and how many were challenged for cause.
And would you say that that had any impact in the was impacted by the process employed?
I'm not sure I understand.
Well, you would expect defense counsel to challenge for cause regardless of whether the court was prone to granting them or not. I
would expect the defense to challenge for cause when a prospective juror has said something that warrants a challenge for cause. The challenges for cause that were made in this case are all, in my view, justifiable. In the end, we had 6 jurors on the final jury panel that the defense had challenged for cause, including juror WB. We had 2 jurors who expressed opinions of guilt and were challenged for cause on that basis and sat on the final jury. So for the district court...
I'm sorry, how many did you say you said there were 6 who had been challenged for cause?
Correct.
And how many of them were challenged for the...
Opinions of guilt, 2.
Yes, 2 of the 6. Okay.
Yes. The other 4 were all mitigation, impaired to pro-death penalty, which factors into the question of a fair and impartial juror. So I guess my point to that is that we have outside evidence that shows that this jury was perhaps not as fair and impartial as the district court chose to believe it was.
Was there a point at which Is there a point when a district court judge should disregard a prospective juror's declaration of impartiality? And when is it? If there is, when is it?
Yes, there is. And that's part of the presumed prejudice calculation. And there are quotes in the brief from various cases about the idea of when you have one of these cases that involves so much media scrutiny and so much sort of hysteria in the community long before the case gets to trial, that it's asking too much of a human being we all want to believe that we can be fair and impartial and come into the courtroom and put away everything that we've heard and think we know about the case. But in some cases, in cases like this, where there's that much media saturation, it's really asking a little too much to believe that everybody is going to be able to do that to the extent that they say they will. And that's the whole idea of the presumed prejudice analysis to a venue change, is that we can't necessarily trust all of these jurors when they say, even if they're not even well-meaning jurors.
I guess that gets back to my original question. When is that shown? By your study that shows a certain percentage based on media saturation have knowledge of the case, that's enough, and then we don't move on anymore?
No, there's more than that. There's the extensive evidence that was put on in connection to the change of venue motion relating to
which has occurred in 3 or 4 other cases, which we, not including last week's that we had, the same type of evidence, and we haven't concluded based upon that type of evidence that the presumed prejudice has been met. And what's different about this case?
This is the Carr brothers. We can't pretend that that's not what's going on here. This is a different case than I think one that the state of Kansas has seen in decades, in terms of the level of media scrutiny, in terms of the level of national attention that this case got as compared to any other, the level of focus in Wichita on this case. I think it's truly unlike anything that we've seen in decades. I've certainly never seen any other case like it. So I think we have the combination of a study that has some of the highest numbers that we've ever seen in any of the change of venue cases that have come before this court. We have the media saturation. The record is filled with exhibits from both videotapes from news reports online or on TV and written news that rose even to the national level. The focus in Wichita on this case was unlike anything we've ever seen before. And I would submit, if this is not the case where this court would say a district court has abused its discretion in failing to change venue, then there is no case.
But that almost strikes against you when you say, well, there was national exposure and you're going to move this someplace.
Except if the national exposure were infecting all of the rest of Kansas, we wouldn't have seen the numbers that we saw from Wyandotte County. The fact that a case makes national news is perhaps most noticeable to the people in the local community who are truly affected by it and looking for the case. And I think that's the distinction. If there are no other questions, I would submit the remaining issues on our brief, and I would respectfully ask this court to reverse Jonathan Carr's convictions.
Do we have any further questions?
Hold on just a moment, if you will. Okay, thanks.
Thank you.
Any further questions? All right, thank you, counsel. As counsel is approaching the lectern, I thought I would announce the court will take a break after his presentation and before the rebuttal by opposing counsel.
May it please the court, David Loudon, Assistant District Attorney for the state. I'd like to spend my time, if I might, just addressing some of the issues that were raised during counsel's argument. I too would submit the rest of the issues on the brief to the extent there are no questions from this court. There's been a lot of focus this morning given to the strike on WB, and as I sat through the prior argument on this, some things struck me that I think deserve attention before we get into the meat of it. Under Batson and McCollum, there's a three-part test, obviously. What concerns me is I think there were some misstatements or suggestions regarding what that test requires. The first step, obviously, is the prima facie showing by the person opposing the strike. The next one is the requirement.
And what was that here?
That here was what the law requires on the prima facie showing. It's not much, Your Honor. The law states, federal law states, that the state need only indicate whether the prospective juror is a member of a cognizable racial group, and that he was the focus of a strike.
Would be a member of a racial...
A minority group, Your Honor. And this person was undeniably black, and he was undeniably the focus of a strike.
And it doesn't...
That meets the prima facie challenge.
And it doesn't matter what the defendant's ethnicity is?
It doesn't, Your Honor, simply because under McCollum, they recognize that you need not share or have opposing races in order to do the strike. What would be suggested by that notion is that we could never challenge successfully, for instance, a black-on-black strike. We're not here today to determine the believability of the state's reason on that prima facie showing, at least initially.
And we're not here to decide the believability of the second step either, are we?
Well, I'd have to clarify, Your Honor, but per se, no. What is required is that there were race-neutral reasons. There was something that Justice Biles was referring to concerning whether the antagonistic why not would be a race-neutral thing, yes or no. And I would tend to focus on, look, is it race-neutral? Yes. Whether the court believes that is a separate question. Who has the burden to show that? That would be the state. The blending of the second and third steps, as is suggested by counsel...
It's not the believability, it's whether it's pretextual. Whether it's hiding a discriminatory purpose.
Well, sure, and I think there's a credibility finding of that. I mean, certainly you can't suggest that the defendant could openly... if he gives a reason and he says that I'm striking him because he's black, I mean, that's obvious and that would never fly. So there is a certain component in any reasons that are given in light of everything that's happened in the record as to whether the state or the person who's opposing the strike has met its burden. I don't think we can absolutely say, well, for instance, there's some discussion about what the court sees, if it's a sigh or a slumping down or something, as Justice Rosen, I think you pointed out, and I'm sure you've experienced this, is where the state gives a reason, I didn't like his body mannerisms. And this court is often loath to believe that because the record sometimes doesn't reflect it. But there are times in the record where the court would say, yes, I saw that. And, if it goes, and I don't think there's any quibble with affirming the court's decision if you believe something like that.
The problem we have here is we don't know, right? So do we just assume that the court made the necessary conclusions to support?
Well, interestingly enough, it was that question from you that bothered me. That was one of the things that bothered me as I listened to the other argument. The standard of review here is abuse of discretion, and there's good reason for that. It's not something we're going to pay lip service to because we disagree. One thing that we cannot discount in this case is that there was somebody in the room who was required to make sure this was a fair trial, and that was Judge Clark. Judge Clark, unlike appellate counsel of any nature, whether it be the defense or the state, had the ability to view what was going on in that trial. when the questions were being asked. Watch the entire process. It's a perspective we don't have. Too often we're reading through a transcript and we're reading like it's just going like this. And what we don't know is, was there a pause? Was there a hesitancy? Like with the antagonistic aspect of the why not. In the first case, Ms. Parker was contesting, whether it was antagonistic or not. The defense is saying it was antagonistic. To me, it doesn't matter.
What about what would we have to observe with regard to defense challenging the state's strike of the other African American? In other words, proposing or being a proponent for African Americans to be on the jury before it made this strike. There's nothing there that I can see that I need to view for that to be relevant evidence for me. Tell me what I'm missing.
Your Honor, I'm sorry. I'm not. I don't want to. I want to answer your question, but I'm not quite sure what you're talking about.
You're saying that we can't view this because we weren't in the courtroom to assess it.
Okay.
Some things are simply facts, and it is a fact that the defense challenged the state's attempt to strike African American jurors.
True.
And we can assess what that fact means as to whether the defense was acting in a racially discriminatory manner without having viewed anyone's demeanor, can't we?
No, I don't think so, Your Honor. Again, that was another thing that the fact that we are talking about it and indicating and recognizing that there can be two sides to this situation is an indication to me that this court cannot stand in the shoes of the only court that viewed the entire process.
Is it your view then that a court's decision on a peremptory challenge when challenged for Batson is not reviewable on appeal? That's not our law.
It's not, and I'm not suggesting that at all.
So we know we can review it. I mean, so you can't just say
Absolutely.
the appellate court is trumped because we weren't there. We get to review this.
Right.
Use of discretion. So what we have are, I think, 3 or 4 sentences from the district court that we can review for abuse of discretion.
True.
And the only thing he says is, well, I just don't, he says this cuts both ways, and I find the reasons stated, which are the reasons stated by the defense, might be supported under a certain interpretation, but they are not adequate under the law. Now, I know what the law is, and I can apply the law to what the defense counsel said. And that's what we got to wrestle with here. So I don't think we can dismiss this as saying the appellate court wasn't in the room. If you are saying it's a credibility determination, the trial court didn't tell us it was a credibility determination. It said those reasons aren't adequate under the law. And abuse of discretion, we can look at the law. So that's why everybody's having to focus on this.
Well,
we got a very thin ruling from the district court on, what's a reasonably serious issue.
I'm not going to say that I entirely agree with your concern. However, I can certainly appreciate the fact that you are. And that's why I wanted to get into the law part of this. There's been some discussion about, for instance, Justice Johnson was bringing up the prima facie thing. The law says, for instance, once one of the parties gives race-neutral reasons, the decision on whether there was a prima facie showing is irrelevant. So it concerns me that we're talking about that, especially when we did make that prima facie showing. But as we move down the spectrum One thing that concerned me in the first instance was the third step itself. The third step does not require the state to say anything or do anything before the judge makes the ruling. The judge is the ultimate arbiter, and I recognize the weakness here because the judge doesn't say anything. But one thing the law does say as well is the judge is not required to state anything, state any reason that would be sufficient. And I would challenge this court in many circumstances after you've reviewed everything. How satisfied would you be if the court just mentioned one thing? Yes, he was slumping. I'm going to, for instance, not slumping, that wouldn't be a good one, but what does he have to say to satisfy this court outside of the entire record? And I would submit, like many other abuse of discretion type situations, we look at the entire record to see if there's anything that would support it. In this case, the state submits that there are 3 other jurors who had that, and I recognize maybe that's not binding, but it is something.
Let me tell you the concern I'm having.
Okay.
It's when the trial court says, after the defendant has made their race-neutral reasons, the trial court says those reasons aren't adequate under the law. And I thought you had the burden of proof on this challenge. And so how can anything they do be, inadequate? Because you got to carry the day, not them. And the only thing you've said is, I object. You didn't even give a reason.
That's not true. That's not true, Your Honor. 2 things. I will recognize that Judge Clark's terminology may not have been the best terminology. In reading that statement, you're also reading something into it that may or may not be there. I think there are 2 interpretations, at least 2, as to what he was saying. And the thing, as we noted before, is we're hanging our hat on his express determination before the Batson challenges started, a recognition of the Bolden case, a recognition in that case that got remanded because the judge merged the second and third steps. So you have a judge here who's told you that he's read the very case that got reversed and it has the test. He's asked the attorneys if they've read that case, in which I think, I don't believe they had, but nobody was working under the impression that they misunderstood what the test was. I understand that this isn't controlling, but it means something. In this heated arena that we had at trial, this court has seen that the attorneys were not shy about complaining when they thought there was an injustice. When the court makes his strikes all the way from one of the first Hispanic juror, I want to use her name, the first Hispanic juror, and all the way through. There are some times when Judge Clark has said some things or done some things, but the bottom line is, throughout all that, the attorneys didn't complain that the judge was somehow putting the burden where it didn't belong. This court should know from its time on the bench and the cases that it's done, oftentimes, that prima facie showing may get blurred a little bit to where, there would be objection. And then the next thing you know, out of the prosecutor's mouth, for instance, they would start blurting out the reasons without any, affirmative showing about whether this person was Hispanic or black or whatever it may be. And then when it's done, the judge will just simply make a ruling. The fact that it's difficult to make a ruling is not an indication that the court somehow abuses discretion when there was no requirement whatsoever that it specify every reason used. And so that's why I say when we look at the record, this record isn't devoid of reasons for why the judge would do that. We've provided this court in our brief with those reasons, which include, and I don't think you can ignore this simply because it was used as a prima facie reason, and that was there are 2 blacks left on the jury, and they're trying to strike one of them. Okay, that was enough to trigger an inquiry by the court. Okay, if that's all we had, along with everything else the judge saw, that is enough for the court to say the state has met its burden of making this strike.